Registrar, would you please call the matter?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados, judgment delivery in CCJ Appeal BBCV number 2 of 2021 between Sandy Lane Hotel Company Limited and Juliana Cato, Wayne Johnson, and Charmaine Poyer. The members of this afternoon's panel are Mr. Justice Saunders, President and Presiding Judge.
Good afternoon, everyone.
Mr. Justice Witt.
Good afternoon, Counsel.
Mr. Justice Anderson.
Good afternoon, Counsel.
Madam Justice Rajnath.
Good afternoon, Counsel.
And Mr. Justice Barrow.
Good afternoon, all.
May we have the appearances, please? Thank you.
Please, you, Mr. President, members of the court, I am Satya Kisoon. I appear on behalf of the appellant, Sandy Lane Hotel Company Limited, and with me is Ms. Joya Reese.
Yes.
Good afternoon. My name is Nyla Robinson, and I appear on behalf of the 3 defendants. I apologize for the absence of Mr. King.
Yes. Good afternoon again, Mr. Kisoon and Ms. Robinson, and we're sorry for the late start. That's due entirely to my fault. The judgment in this case was a unanimous one, which was delivered by Madam Justice Rajnath. I would ask her now to give a summary of the judgment.
Thank you, Mr. President. Thank you. This summary is not intended to be a substitute for the judgment of the court or to be used in any further consideration of the court's judgment. Juliana Cato, Wayne Johnson, and Charmaine Poyer, we refer to them as the employees in this summary, who were dismissed by Sandy Lane Hotel Company Limited, the company, in 2011, individually brought actions against the company in the Magistrate's Court. They claimed damages for wrongful dismissal under Section 45 of the Severance Payments Act of 1971. The company denied liability, stating that the employees had been properly and lawfully dismissed, and Section 45 was therefore not applicable to them. The courts below agreed with the employees. The magistrate held that the collective agreement executed by the Barbados Workers' Union, of which the employees were members, and the Barbados Employers Confederation for the Barbados Hotel and Tourism Association, of which the company was a member, was explicitly incorporated into the contracts of the employees, and that, based on the terms of that agreement, the dismissals were unlawful. The magistrate ordered the company to pay damages in the sums claimed. The Court of Appeal also held that the employees had been wrongfully dismissed and were entitled to damages, but on the ground that it was not lawful for them to be dismissed without the company following the disciplinary process incorporated into the employees' contracts, including the champion rules of the game. The Court of Appeal agreed with this conclusion and dismissed the company's appeal. The court agreed with this conclusion and dismissed the company's appeal. The employees were all dismissed in a similar manner. On 30th January 2012, each of them was required to meet individually with the human resources manager. The HR manager told them about claims made by a particular hotel guest, the mystery shopper, in a report given by that guest to the company that they had performed poorly in serving that person. They all protested the claims, with Ms. Cato stating that she didn't even work in the specified facility on the evening in question, as alleged in the report, and Ms. Poyer indicating that 2 weeks earlier, the reservationist manager had congratulated her for an excellent interaction with the mystery shopper. The manager had informed Ms. Poyer then that training would be provided on areas that needed to be improved. In spite of this, all 3 employees were handed already prepared letters of dismissal by the HR manager, together with a week's wages in lieu of notice and outstanding monies due to them. They were asked to collect their personal items and then escorted off the property. The letters were all similarly structured, alleging that an investigation revealed that there was substandard performance in relation to the mystery shopper, that this poor performance led to a decline in the overall rating of the company, and that each employee would be dismissed with a week's wages in lieu of notice. The HR manager admitted that the purpose of the meetings was to terminate the contracts, but that this was done in accordance with the contracts as she looked at the contracts and used the best option available to terminate the employees. The court found that the company could not rely only on the letters of employment as a defense to these claims, as no provision for payment in lieu of notice is to be found in those letters. Without resort to the rules, which includes this provision for payment in lieu of notice, dismissal with such payment in lieu would be a breach of contract and therefore wrongful. The rules did provide, however, for much more than just payment in lieu of notice. The rules embodied a full disciplinary code of both substance and procedure, inclusive of a long list of specific offenses. That list included the offenses of which the employees were accused in their respective letters of dismissal. The disciplinary procedure set out in the rules required written notification of hearings in instances where suspension or dismissal was possible. That notification had to include the charges against the employee and the date, time, and place of the hearing. Employees needed to be informed of their right to have shop stewards or union officials or a friend present during the proceedings. Paragraph 4 of the procedure clearly stated, no case involving disciplinary action shall be brought against an employee unless the above steps have been taken, except in instances which warrant summary dismissal. Paragraph 5 boldly promised that any disciplinary action taken without following the above procedure shall be set aside. The rules specifically indicated under the heading performance that if your performance is not satisfactory, you will be given every opportunity through counseling, training, and retraining before being terminated for poor performance. The court acknowledged that the rules made provision for dismissal with a week's notice or week's wages in lieu of notice, but there was nothing in the rules to suggest that this provision was overriding. Moreover, that provision was at variance with the elaborate provisions for the disciplinary procedure to be followed before an employee is dismissed for poor performance. The court rejected the notion that the dominant party in the relationship can simply cherry-pick the rule that worked best for it and ignore all others. The court employed the contra preferentum principle. That principle allows the court to construe inconsistencies in a contract against the interests of the party who wrote the contract, especially where, as here, that party is the dominant one in the relationship. The court held that it is only reasonable that the provisions that specifically addressed substandard performance should have been invoked by the company instead of the general provisions for dismissal with 1 week's wages in lieu of notice. The court agreed with the Court of Appeal that the rule should be interpreted in context. This context changed with the passage of the Employment Rights Act 2012 of Barbados. This later act was not operational at the time the employees were dismissed. The employees' contracts must therefore be interpreted on the understanding that the law at the time of their dismissal did not allow them the option of making a claim for unfair dismissal. The court also noted that the common law implies into every contract of employment a term of mutual trust and confidence to ensure that employees are treated fairly and that employers do not conduct themselves in a manner that destroys or seriously damages the relationship of confidence and trust between employer and employee. The court thus held that the company not only breached the express terms in its own rules by sending home the employees who had given a combined total of almost 30 years service with a bare minimum of 1 week's notice, but it also breached the implied term of mutual trust and confidence. Having found that the employees had established that there had been a breach of their contracts, that this resulted in wrongful dismissal, and noted that the employees had claimed damages, the court held that the employees were entitled to have their damages assessed at an amount not less than if they had been made redundant and were entitled to severance pay in keeping with Section 3 of the Act. The court thus dismissed the appeal with costs to the employees calculated in accordance with Rule 17.15 3B of the Caribbean Court of Justice Appellate Jurisdiction Rules 2021. Thank you so much, Mr. President.
Yes, thank you. Counsel, have those damages been agreed by you? It's a mathematical formula, I imagine. Has that been done?
Not in the intervening time, Mr. President, but there have been discussions between the parties in the years previous, which solidified what those figures would look like. And I highly suspect that we would not need to go to the magistrate for the assessment.
Right. This is what I'm thinking, that if you can agree, and perhaps we can, but we can't order you to agree, but if you can agree within a week's time, then if you provide those figures to us, then we can make them a part of this order so that it would obviate the need for any further proceedings in any other forum.
I'm certain that that could be done. I would defer to Ms. Robinson, but I doubt highly that there'll be any contention on the figures.
Yes.
I agree, sir.
Okay. Is there anything?
There was no provision for interest. Does the standard interest apply?
Interest on that sum? From what date?
Sir, under our Caribbean CPR, it would be 4% from the date of filing and 6% from the date of judgment. But as this was filed in the magistrate's court, I'm thinking, well, we would think that we were thinking that was the rate of interest which would apply.
Well, I don't want to brainstorm that, but if you can both agree on that, then, you know, you
Thank you, sir.
Give us a consent along those lines and we would embody them in the court's order.
We shall do so, Mr. President.
Yeah, okay. Is there anything else?
Not for the appellant. We're obliged to work.
Okay. All right, well, thank you very much and have a good afternoon. Madam Deputy Registrar, can you please close the proceedings?
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnatley. Thank you, Mr. Justice Barrow. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Okay.